Today, we're cracking the code on a system that is, no joke, the backbone of all legal writing in Canada. We're talking everything from first-year law school papers all the way up to Supreme Court decisions. So let's dive right in.
I want you to just imagine for a second. You're standing in a massive library that holds every single law, every court case, every legal argument ever written down in Canada. And your job? Find one single crucial sentence. I mean, where would you even start? The scale is just immense. It's completely mind-boggling. But there is a system.
You use the law's very own GPS. Seriously, that's the best way to think about legal citation. It's a standardized, uniform system of coordinates that can pinpoint the exact location of any piece of information, no matter how deeply it's buried. So, you see, it's not just some tedious rule to follow. It's an incredibly powerful navigation tool.
In the map for this GPS system here in Canada is the Canadian Guide to Uniform Legal Citation. You'll almost always hear it called the McGill Guide. It's the official rulebook that brings a whole lot of order to what could easily be total chaos. Now, this guide doesn't just appear out of thin air. It's actually the result of this really unique collaboration. As you can see, it's meticulously put together by the student editors of the McGill Law Journal, and then it's published by Thomson Reuters. It's this amazing link between the academic world and the legal industry.
And trust me, this is not some dusty old rule book that never changes. The first edition came out way back in 1986, and for nearly 40 years now, it's been constantly evolving. A new edition comes out roughly every 4 years to adapt to changes in the law, in technology, and in society itself. The 10th edition, which came out in 2023, is just the latest step in this long tradition of keeping the entire legal world in sync.
So how in the world does the guide organize this whole universe of legal information? Well, it breaks it all down into 3 foundational categories, or what you can think of as pillars. Understanding these 3 pillars is the absolute key to mastering the system.
First up, we have legislation. Okay, so these are the actual rules, the laws that are written and passed by the government. When you think of a law, like, say, the criminal code, you're thinking of legislation. This is the bedrock, the foundation of everything else.
Next up is jurisprudence. It's a bit of a fancy word, but it really just means court cases. You see, laws aren't always crystal clear, so judges have to step in to interpret and apply them to really specific situations. Their written decisions, the rulings, make up the second pillar. It's basically the law in action.
And finally, our third pillar, secondary materials. This bucket holds everything written about the law. We're talking articles in law journals, textbooks, expert reports, you name it. This is where legal scholars and experts get to analyze, critique, and discuss the other 2 pillars. And here is where it all just clicks into place. This right here is a bibliography from a real legal document. And look at that! Notice how it's organized? Into those exact 3 sections we just talked about. Legislation right at the top, then jurisprudence, and then secondary materials. It's a perfect example of the guide creating real, tangible order.
Okay, so we've got the what. Now let's get into the how. We're going to look at the 2 main ways citations pop up in legal writing, and then a couple of clever little Latin shortcuts that make everything much more efficient to read and write.
So you've basically got 2 main styles, in-text and footnotes. In court documents, think of a factum or a written argument. The citations are put right there in the paragraph. This lets the argument just flow without interruption. But in academic writing, like a law journal article, you'll see those little superscript numbers that point you to the full citation down in a footnote. That keeps the main text looking clean and super readable.
Now, to avoid being super repetitive, legal writers use some pretty simple shortcuts. First, you always cite a source in full the very first time you use it. Then, if your very next footnote refers to the exact same source, you just write ibid, which basically means in the same place. And if you need to point back to a source you cited, say, several footnotes ago, you use supra, which means above, along with the footnote number where you can find it. It's a really elegant system for keeping things concise.
So here's the crucial point, the real takeaway. This isn't just about following some random rules to avoid getting a bad grade. Mastering legal citation is, and this is key, it's a tool of persuasion. It makes you a stronger, more effective, and frankly, a more believable writer.
But hey, don't just take my word for it. In his foreword to the 10th edition of the McGill Guide, Supreme Court of Canada Justice Mahmoud Jamal puts it perfectly. This statement right here is so powerful. Caring about citation, it signals something much deeper about the quality of your work and your argument.
Justice Jamal breaks down the why into 3 key benefits. First, the most practical one. It helps your reader, whether that's a professor, a partner at a law firm, or a judge, find your source material, instantly. Second, it gives crucial context, like the year a case was decided or the level of court. And third, it adds this layer of professionalism that lets the reader focus on your actual argument instead of being distracted by messy formatting. As we saw with all those different editions, the McGill Guide is not frozen in time. Not at all. The editors are constantly working to keep it relevant, adding rules for new things like citing online sources, social media, and even emerging tech. It adapts as our world adapts.
And here is a really profound example of this evolution, right in the 10th edition. It includes a formal statement of commitment to engage with the Truth and Reconciliation Commission's calls to action. The editors are now working with Indigenous elders and knowledge holders to develop a unique way to respectfully and accurately cite Indigenous sources of knowledge for the next edition. It's a huge step.
So let's end with this thought from Justice Jamal's foreword. He quotes a scholar who said that for a writer, accuracy is a duty and not a virtue. Think about that. It's not something to be praised for. It's the absolute minimum standard. The McGill Guide is a tool for fulfilling that duty in the legal world. But it kind of leaves us with a bigger question, doesn't it? What would our public conversations look like if everyone treated accuracy not as an optional virtue, but as a fundamental duty?